This is 9/11 Freefall.
Good evening, ladies and gentlemen. Welcome to another episode of 9/11 Freefall. My name is Andy Steele, and I am the host. Tonight, we'll be joined by Richard Gage, Mick Harrison, and Dave Meiswinkle, principal players at AE 9/11 Truth and the Lawyers Committee for 9/11 Inquiry, and they're going to be talking about the lawsuit that's been filed against the FBI for overlooking important evidence in the case of 9/11. They'll be talking about that in further detail, and this is a long interview, so we're going to jump right into it tonight. I'll be bringing that to you in just a moment.
The views expressed on this show by guests and the host on issues outside of the 9/11 controlled demolition evidence are the opinions of those individuals alone and do not necessarily reflect those of architects and engineers for 9/11 Truth.
All right, I have the two gentlemen from the Lawyers Committee. Of course, there's many others on that board, but I have the two that were here last time who were talking about the grand jury petition back on to talk about the exciting new developments taking place with their organization, with AE 9/11 Truth also, and of course, we have our CEO on board. So let me introduce them all to you. Mick Harrison, Esquire, is the Lawyers Committee for 9/11 Inquiry's Director of Litigation. He is a public interest attorney. He's a graduate summa cum laude of the University of the District of Columbia School of Law. He has a national practice focused on cases that involve whistleblower protection, government accountability, corporate fraud and false claims, and dangers to public health or the environment. Over the last 25 years, he has worked in partnership on such cases with the Government Accountability Project, Public Employees for Environmental Responsibility, the Chemical Weapons Working Group, the National Sierra Club, Greenpeace, and Vietnam Veterans Organizations, among others. Mick Harrison, welcome to 9/11 Freefall.
Thank you, Andy.
And he's joined by Dave Meiswinkle, Esquire. He's a criminal defense attorney, a retired police officer of 23 years, and a former U.S. Army veteran. He founded the New Brunswick Taxpayers and Tenants Association and the New Brunswick Reporter, a community newspaper. His activism and articles outlining municipal corruption brought federal authorities into New Brunswick, New Jersey, which led to major criminal investigations and arrests, indictments, and convictions of prominent local politicians. He's also been an independent candidate for governor and Congress in New Jersey, and he's currently on the board of directors for the Lawyers Committee for 9/11 Inquiry and was a panelist at the unprecedented 9/11 Justice and Focus Conference. He's been a guest on this show many times in the past. Dave, welcome back to the show.
Thank you, Andy, very much.
And of course, we're joined by Richard Gage, AIA. He's a San Francisco Bay Area architect of 30 years, a member of the American Institute of Architects, and the founder and president of Architects and Engineers for 9/11 Truth, the organization that brings you this program. During his architectural career, Richard has worked on most types of building construction, including numerous fireproof steel-framed buildings. Richard, welcome back to the show.
Thanks, Andy.
All right, so I'm going to have Richard lead it, and I'm sure that this audience is already aware of the developments taking place. A lot of excitement around that. I can see the emails coming into our information email address. And so they already know it, but we're going to lay it out here for those few people who may not have checked their inbox for the last week. Richard, tell us exactly why you guys are back on this show and what is AE doing with the Lawyers Committee now?
Well, Andy, for 12 years, the architects and engineers have been compiling evidence for the explosive destruction of the 3 World Trade Center skyscrapers on 9/11. And we have been taking this information to the public, more specifically to the media, to elected representatives, to the academic and building professionals throughout the country and actually around the world in more than 600 presentations in like more than 30 countries and 100 American cities, and yet we have not been able to get this compiled, detailed list of evidence into discovery phase in a lawsuit. And so for 12 long years, we have been trying to make headway here, and so fortunately for us, we were able to work so closely with the Lawyers Committee for 9/11 Inquiry. In 2016, we had a major conference where we presented this evidence before a body of a dozen attorneys, including Danny Sheehan and Lionel Media. And this has resulted a couple of years later now in not only the petition to the grand jury, to the U.S. attorney, to impanel a grand jury to investigate this evidence, which we discussed on your show a couple of months ago. But now we are suing the FBI because they failed to incorporate the evidence that they were already aware of into the report, the 9/11, well, to the commissioners of the 9/11 Review Commission, which was mandated by Congress. Now, Mick and Dave will explain the details of that, but now our evidence, which the FBI has actually seen and responded to in a letter in 2008 from the Assistant Chief of Counterterrorism, Michael Heimbach, who was sent our DVD 9/11 Blueprint for Truth by Harold Save in Florida. They responded to him and said, Mr. Gage's theory is an interesting theory backed by thorough research and analysis. So that proves that they saw it. But, and it has all the evidence that we're going to be talking about in some detail here on this show. And yet, the FBI did not act according to the law and present this evidence to that review commission when it produced its report in 2015. So that's what I'm all excited about, and I'm joined by two esteemed colleagues here, which I'll let you turn it over to because they've got a lot more specifics than I have on this, but I'm just honored to be working so closely with them and to be raising the funds necessary to make sure that we have a successful completion of this lawsuit so that this evidence can get into discovery and that the FBI will present to Congress the explosive evidence of the destruction of these three skyscrapers.
That's right, and whenever you do anything this important, you got to do it right and do it big, and we're going to be getting into how our supporters can help out, because it's not just the Lawyers Committee for 9/11 Inquiry, it's not just AE 9/11 Truth, the people that work at these organizations, it's all of the people who have cared about this issue for all the years since they first woke up, whether it was like back in 2006 like Richard, or if it was in the last 3 weeks. We just got a letter from someone who woke up 3 weeks ago because of what's going on now and is all ready to go and wants to help out however they can. But people have been following this for a long time, and so we need all the support. We're going with all of our weapons here in so many different theaters. Really exciting to see this development coming. So I'm going to turn it over to Mick, and I'm going to get into some of the nitty-gritty so that our audience and myself understands what we can expect to see over the next following months and year. But just from your own perspective, why is this action, taking on the FBI, an important and strategic move to make at this point?
Well, Andy, the goal of the architects and engineers, the Lawyers Committee, and family member Bob McIlvaine is to force the FBI to do what Congress has already ordered it to do in a congressional mandate. So the Congress wanted to keep itself informed about 9/11 evidence. And so in 2014, the Congress directed in a public law the FBI to have an independent commission assess all evidence regarding 9/11 known to the FBI that was not considered by the original 9/11 Commission. And so this lawsuit is important and strategic because it's helping the Congress inform itself on all of this important evidence that's come out regarding 9/11 that was not considered by the original 9/11 Commission. And foremost among that evidence is the evidence of demolition of 3 World Trade Center towers on 9/11 that Architects and Engineers has so well developed and presented to the public over the last decade. So we are cautiously optimistic not only about winning the lawsuit, but that it will in fact require the FBI to assess this evidence and to report it to Congress as required, at which point you're going to have a much better informed Congress and a much better informed American people on this new evidence, which I'm sure we'll get into.
Dave, same question. I mean, there's a lot of people to sue when it comes to 9/11 in my humble non-lawyer view, but why the FBI? Why now in your view?
Well, as Mick mentioned, this was some legislation. There's a mandate here that the FBI was to assess the evidence, and that was between 2004 and 2014, that was not considered by the original 9/11 Commission. So what we're asking in this lawsuit basically is for injunctive relief. We're asking for the judge to make a declaratory judgment that in fact the FBI had this responsibility, and now I'm ordering them to do what they are obligated to do under the law, and that's to make that assessment of this evidence that's listed in the complaint. And there's 7 categories of that. So that's really the significance, is that the government up to now, and in particular the Federal Bureau of Investigation, the Department of Justice, they did not comply with the original legislation, and this is mandated to address this to Congress. So we're asking them to just comply with the law, basically. And now the areas that we're asking them, besides the all-important pre-planted explosive evidence at that was involved in the bringing down the towers and the Building 7, and that had to do with explosions and bombs and controlled demolition, is evidence that links other important areas involved in the crimes of 9/11. And that would include, and I'll just list them, and then we can go into depth, and Mick can supplement it, and I can also. It has to do with people that were celebrating or actually documenting or filming the event around 9 o'clock in the morning. And as we know, that the first plane hit around 8:48, and I think the second plane hit around 9:03, the towers. That was North and South Tower. And they were eventually arrested in New Jersey. And they had important film that was confiscated by the New Jersey State Police. And they had a police dog that went through a van, and it tested positive for explosives and on a fabric and a blanket. So no, the public has never been advised of that, or at least we're most certain that the 9/11 Commission did not consider that, and there's not been a proper assessment by the FBI of that. But there's also areas that have to do with the destruction of evidence, the areas that have to do with the Saudi financing, and there are another count has to do with cameras mounted in and around the Pentagon that the public is not aware of, and certainly the 9/11 Commission did not have that information to consider. There has not been a proper assessment. In addition, the plane parts have serial numbers on, which can identify the planes at all 3 sites. There's been controversy over what actually happened as far as planes, what planes hit the buildings, and in particular at the Pentagon. And then there's cell phone communications that drastically changed from earlier on, that the 9/11 Commission had certain information that they drew conclusions on, and then during the Moussaoui trial in 2006, there was a total flip, a reference to cell phones and airphones, and one very important call made by the Solicitor General's wife. So that's some of the areas, Andy, that we are the count that the complaint that was drafted by Mick includes, and it has really propelled the investigation, or at least as far as the lawyers, and I believe as far as the efforts of the architects and engineers, to another level. We're expanding and in a very credible way this issue, and now it's not just as a petition to the U.S. Attorney to investigate the crimes in New York City dealing with explosive evidence, but it also expands the areas of interest to the entire overall crime of 9/11, in addition, of course, to New York City.
That's right, and it's like we're coming out of the hills now and coming at them from all fronts. It started with the Bobby McIlvaine Act, where we get them on the legislative front. We're still continuing our efforts there, and then the grand jury petition. Now this. It's almost like the culmination of all of the suggestions and wishes of the 9/11 Truth Movement are suddenly coming true. You know, wouldn't it be great if somebody sued the FBI? You know, if AE could do that, if a lawyers group could get formed and do this, and now here we go. It's all happening. Now, Dave, you talked about some of the other elements of September 11th that's out of AE's scope, but which is included in it, and I think it's important to investigate every single aspect. I mean, nearly 3,000 people died in this incident. We're still affected by it. I mean, 9/11 is still invoked whenever they want to pass some legislation that further clamps down on our liberties here. So, you know, if there's any questions about any of it, it should be explored. All of the information should be made public. There's no reason, I don't care, I don't believe that there's any kind of national security threat in disclosing all the information that you just laid out there. The American people deserve to see it, regardless what it shows. Either it puts these questions to rest, or it opens up a new door where we can explore who might have been responsible for orchestrating this even further. But Richard, with the FBI report omitting evidence related to AE 9/11 Truth Mission, can you briefly just go over some of the stuff that the FBI failed to consider that you outlined to them back in 2008 when you sent them that letter?
Yeah, Andy, there is so much that we packed into that documentary that the FBI saw. We start with Building 7, which is, for those who don't know, a 47-story skyscraper that collapsed in the afternoon of 9/11 after witnesses heard explosions straight down uniformly, symmetrically into its own footprint in the exact manner of a classic controlled demolition. So the videos themselves prove controlled demolition. Remember, fire, the official cause of this building's collapse, as claimed by NIST, the National Institute of Standards and Technology, has never brought down a skyscraper, ever, much less in the exact manner of a classic controlled demolition. So NIST had their hands full while they were fumbling this football for 8 years. So this evidence, the NIST report itself, which is replete with fraud, came out after the 9/11 Commission report. That was probably one of the whole points, is to delay that 7 years, where people, especially building professionals, wouldn't even hear about it. The AIA, for instance, of which I'm a member, the American Institute of Architects, hasn't issued one bulletin on the third worst structural failure in modern history. That's a crime in and of itself, a subject for perhaps another legal action. But Building 7, the actual report that came out in 2002 shows sulfidation of the steel, which is documented in a metallurgical examination of the steel by a top university, which documents a liquid molten iron invading the grain boundaries of the steel. This doesn't happen by normal office fires. This happens only with thermite. There's evidence of thermite as well. Thermite is an incendiary used by the military to cut through steel like a hot knife through butter. And the temperatures documented at all three World Trade Center skyscrapers exceed 2,800 degrees. The hottest office fires are about a third of that temperature. So where is this heat coming from? Well, the dust itself is composed of iron microspheres, which are evidence of temperatures exceeding 2,800 degrees. It's also evidence of liquid molten iron having been aerosolized in an explosive environment. The U.S. Geological Survey finds up to 10 tons of this material throughout all the World Trade Center samples that they studied. This is evidence of the use of thermite incendiaries. There's no other explanation for the elemental iron, for the extreme heat, for the sulfur that's present in these spheres. NIST had claimed that the sulfur came from the gypsum board, but we've used gypsum board for almost 100 years to protect the steel. It's never turned around and attacked it. So we have the evidence also found and documented after the 9/11 Commission report, which the FBI was required to assess and report to Congress, of small dual-layered red-gray chips, up to 10 tons of this material in all the World Trade Center dust, as documented in the peer-reviewed paper Bentham Open Chemical Physics Journal. In that journal, this paper was documented, and what did it find? It found that these dual-layered red-gray chips are actually nanothermite, and they were applied with fluid. So they thought they were paint at first, but they are attracted to a magnet. They put them in a heater, a differential scanning calorimeter. They find that they produce an energy at 758 degrees. They ignite and produce much more energy, indicating that it's thermitic. So they zoom in 50,000 times with an electron microscope and find the individual ingredients of thermite at the nanoscale. We're talking 1,000 times smaller than the diameter of a human hair. All of these particles, rhomboidal-shaped iron oxide crystals in aluminum powder set in an organic bed of oxygen, silica, carbon. This is an ingredient of an incendiary that's been engineered to become more explosive. So the FBI failed to report this to Congress. In fact, I'm looking at a letter from the FBI lab on May 5th of 2010 to Representative Jim McDermott from Washington on behalf of a constituent who is a supporter of ours. And the FBI is writing, the congressman, I am writing to you in response to your letter of February 18, 2010 on behalf of Mr. Jeff Risch and his colleagues. In the letter, which was referred to my office for response, Mr. Risch provided a link to the webpage for architects and engineers for 9/11 Truth. The investigation, he says, into the September 11th attacks received unprecedented attention from the FBI, as well as other federal, state, and local agencies. Highly qualified evidence recovery technicians and laboratory personnel processed a large quantity of debris for investigation and leads. We reviewed the referenced article and concluded, and that's the nanothermite article, the 25-page peer-reviewed paper. So they reviewed that. They concluded that the results from the analysis of the dust samples in no way serve as an indicator that thermite was present in the post-collapse debris. The FBI is confident that the correct conclusions were reached in this investigation, and nanothermite was not used to topple the World Trade Center complex. So clearly they assessed it, and clearly they did not report that assessment to the FBI. So Mick and Dave can respond to the legal implications of that. But this is among the numerous categories of evidence in our documentary, which, by the way, include 100 first responders after the commission report came out in August of 2005. the New York Court State of Appeals had forced the city to release the oral histories of the first responders. And of the 500 transcripts of these first responders, in over 100 of these, now 156 of these first responders are talking about explosions, experiencing an explosion, and many of them before the planes even impacted the building. And in most cases, in addition to that, before the collapse of these buildings ever happened. And so these are extraordinary testimonies that are not describing the collapsing of a floor causing these sounds. Many of them describe a train running underneath their feet, down low in the basement, affirming other eyewitnesses, such as Willie Rodriguez, of explosions in the basement. And in fact, the seismic evidence proves that these explosions occurred in each of the towers prior to the planes hitting the building and prior to the collapse of these buildings. We referred the FBI to the work of Andre Rousseau, more evidence that came out in 2009 and 2012, an applied geophysics expert, author of 50 peer-reviewed papers, who does this very detailed documentation of the seismic evidence, which was not provided to the Congress, according to their mandate, by the FBI. So there's many other categories here that I could go into, but I think I'd love to hear Dave and Mick's assessment here of this particular letter from the FBI lab and see what relevance it might have, because we have the opportunity, I understand, to submit yet more evidence during the following 3 weeks after the filing on Monday. So very exciting opportunities are emerging here live as we speak.
Yeah, and I want to get their assessment of that. I think, they say that they're confident in their findings, but they're not confident enough to explain how the peer-reviewed journal is wrong and what they found otherwise. I don't believe that they're as confident as they claim to be, and I guess we will see if this thing heads to court. Before we get into their assessment of that, I want our audience to understand what is exactly going to happen, as if they're not familiar with it at all. So I'm going to ask Mick, but also Dave, if you have something to add as well, feel free to chime in. Explain what this first step was, and then what can we expect to see in the next following months and year as this goes forward.
Well, the first step was the filing of the complaint. The complaint is the formal legal document that initiates a lawsuit in federal court, and the process involves several steps after that. The first step is that the government now has, I believe it's 60 days to answer our complaint, and they have an option. The normal response is to give a paragraph-by-paragraph response to our allegations in the complaint, where the government, the FBI, would actually have to say, we admit this or we deny that, paragraph by paragraph. And we do expect to get to that point where we're going to see that paragraph by paragraph response, which will be a fascinating document to read, because a lot of our allegations come from FBI documents. But the FBI has an option. If they choose not to answer right away, they can file a motion to dismiss if, and only if, they can identify a non-frivolous legal technicality for arguing that the court should dismiss the case without getting to the merits. We don't expect, in this case, to lose on a motion to dismiss, so I do think we're, at some point in the next few months, going to get that paragraph-by-paragraph admission and denial from the FBI on our allegations. Once we get to that stage, the second stage is called a summary judgment, and this case is brought under the Administrative Procedures Act, and typically summary judgment motions are the vehicle used to decide those cases. Occasionally you actually get a trial, and we may get a trial in this case, which would be the third step. But the second step is called summary judgment. At that point, we actually get into the evidence. The first step, I should have clarified, the motion to dismiss, does not have to do with evidence. It has to do with allegations. and whether the allegations in our complaint are legally sufficient, assuming they're true, to get past a motion to dismiss. And in this case, the allegations are so straightforward, there's really no chance, in my view, of losing in a motion to dismiss. So the summary judgment is where we're really going to get to the merits. And at that point, both sides submit their evidence, normally attached to a legal memorandum in the form of affidavits and exhibits that reflect the scientific work, the evidence regarding the Saudi support, the Pentagon videos, and so forth. All that will be submitted by both sides. And if we win on that motion, which we may because of the simple nature of this case, at that point we're going to get the order from the judge to do what Dave Meiswinkle was talking about, which is ordering the FBI to report back to Congress an independent assessment of this evidence. And let me just note a quick footnote here. When Richard was talking about that FBI letter where they were referencing an apparent analysis of the thermite question, and they concluded that thermite was not present, so they're obviously in conflict with the evidence presented by architects and engineers. When Richard said that they failed to report that to the FBI, he meant failed to report that to Congress, and that's a huge deal here because, the FBI is making these broad conclusory statements that the evidence we're submitting is not substantial or has no basis in science and fact, but they don't give us or the public or the Congress their analysis and don't subject it to peer review and public critique. And this lawsuit may force them to do that, and it will be very interesting to see if they even have a document that assessed the thermite question. My guess is that someone looked at it without doing a thorough scientific review and just blew it off. So this lawsuit will cut through the red tape and force the FBI to basically cough up what it has or hasn't done, and in the end should result in them having to report their assessment to Congress. But in addition, it's going to force them to submit their whatever they did scientifically to an independent panel to review as well. So that's how we expect the lawsuit to go. Now, there is a chance if both sides lose on summary judgment, which means the judge determines there are fact questions that have not been resolved by the briefs and the evidence submitted, and that taking witness testimony is required to resolve the fact dispute, and that could happen in this case, there then would be a public trial. And we're talking, probably a few months for each of these steps, so it could take over a year, Andy, to get to the trial stage if we get to a trial, but hopefully not too much longer.
So just, Mick, if we get to a trial, is that a good thing or a bad thing for our side of it? Do we want it to go to trial, or do we want it to not get to that point and for this to be stopped at the second step?
Pretty good question. In a normal litigation, and I wouldn't call this a normal litigation, in a routine litigation, you normally want to win as early as you can. And the first step for the plaintiff to win is summary judgment. And most lawyers would be more than delighted to avoid a trial in a normal case and win on the summary judgment motion. And if we do win on summary judgment, it will be a good thing for the public interest because it's going to mean that the court has ordered the FBI to do this independent assessment of these 6 categories of evidence and report all that to Congress. That'll be a good thing. However, it's sort of a win-win for us in this unusual case because even if we were to lose on summary judgment, and so did the FBI, and we go to trial, the worst thing that can happen there is to have a very public forum to talk about this and to talk about the evidence and talk about what the FBI did and didn't do. I wouldn't expect to lose on a fact question at trial. I mean, keep in mind, this case is not about proving a particular theory of events and how they played out on 9/11, and there are competing theories out there. This case is not about proving that. This case is proving that the FBI failed to do a duty imposed on it by Congress to analyze the evidence and report their own assessment or an independent assessment to Congress, whatever that assessment might be. And so you have a procedural failure here by the FBI that's not very difficult to prove. So, the odds are good, in my view, that we'll win at one of those 2 stages, either summary judgment or at trial, And either way, I think it's a win for the public interest.
Oh, it certainly would be. I mean, we've got everything to gain here and nothing to lose, in my view. One more question based on what you said. So let's say they are forced to update Congress to brief them on new evidence, which is really old evidence, but new to them maybe. In what form would they have to do that? A written report, or do they have to go out in front of a congressional panel and say it orally to them?
Yeah, another good question. At a minimum, there would have to be a written report. And the way this mandate from Congress was worded, it required an independent assessment, an external assessment. So what the FBI has to do is create a panel. They did that the first time in 2015, and there was a 3-member panel. Ed Meese was, I think, the chair. There was a member of the original 9/11 Commission as a second member, and then I think that was Tim Romer, and then a third member from a Georgetown University professor who's an expert on terrorism. That's what they did the first time, where they failed to assess these 6 categories of evidence. And who knows whether that first panel ever got to see any of this evidence. They certainly did not assess it or report on it. So they're going to have to do something similar the second time around. If we get this order from the court, they're going to have to create an independent panel, make sure the panel gets all this evidence. The panel is going to do their assessment, no doubt informed by the FBI's own presentations to the panel, and then the resulting assessment is going to have to be reported in writing to Congress. Now, I would expect, I don't know that this would happen, but I would expect once Congress sees a report addressing these particular categories of evidence, a lot of eyes are going to be open in Congress, and I would hope that certain members of Congress would want to bring the FBI in and possibly bring in some of the scientists from architects and engineers to get the other side and just, hear this verbally in person like they do in their congressional investigative hearings, and that could be quite another eye-opener for Congress, and we may get there.
Well, I know that if this goes our way and we get that, I'll be on the first plane out to D.C. with a copy of the Building 7 study and the FBI's updating of the evidence, a volume there, and I'll be bringing that to every Congress member, because it's pretty hard to argue against the FBI once they're on board with something, at least when you're talking to the political people that point to the agency's assessments and dodge the issue by doing that. Dave, during the press conference, you mentioned the Federal Procedures Act and the Mandamus Act. Now, we touched on the Mandamus Act last time you guys were on, but for new listeners, talk about those and how they're applicable to this lawsuit.
Right. Well, as I mentioned before, is that these are the 2 actions that we're suing under, and they both carry a certain obligation here, in particular for the government not to be arbitrary and capricious in their actions, but to present reasonable or act reasonably. And in regard to this mandate from Congress, it's fairly obvious that the government or the FBI did not do what they were mandated to do, and being that was to make that assessment so that eventually Congress could be updated on the crimes of 9/11, in particular between the time of 2014 and 2004. So what the mandamus action is injunctive relief that both actions carry, and it's basically the judge ordering the FBI to do what they were obliged to do. So that's I think that's the short version of it, and Mick could amplify that, I'm sure, much better. But that's my understanding, that they have a obligation. It's not, again, something that's discretionary that the FBI did not do. And we are basically bringing that to the attention of the court, and we're asking the court to agree with us and then to order them to do what Mick described previously, to eventually make that assessment. They would have to then reconvene that 9/11 Review Commission, which would actually make the assessment, and then report it to Congress, with the hopes that Congress then would go to the next step and really open this procedure up.
So it sounds like the concept of maladministration, which is active in other countries, where you can't just say that you're so bad at your job when you have a public responsibility that you can cover up any personal culpability. You can still be gotten if you've overlooked evidence or made improper calculations, like in the case of NIST. And this is kind of our American version of it. It sounds like to me, and certainly is the banner under which we can pursue this. And I want to know, Dave, I'll ask you this, who are you going to be arguing against? Like, are there going to be people such as the ones that Richard has corresponded with or supporters have corresponded with that will be citing who will be called in, or is that just at the trial phase, or will it just be an FBI lawyer in that room making the case on behalf of the FBI?
Well, Mick would be better to describe that because his experience in the federal court level, but certainly the Justice Department would be defended by their attorneys, and at the earlier stage, as Mick said, it's not going to be a trial. I would think that a lot of exhibits would be considered by the judge, and certainly a lot of the information that the architects and engineers has created over the years, which is actually part of the grand jury exhibit list in New York City. All those exhibits, I think, would be something that would come into play, but I think that's a better question to be answered by our litigation director, Mick Harrison.
Go ahead, Mick.
Okay, thanks, Andy. Well, Dave has it right. The first stage, which is the motion to dismiss stage, or the answering by the government, is basically going to be lawyer stuff. So there's going to be briefs filed by lawyers, no real involvement of witnesses at that stage. At the second stage, though, summary judgment, the first involvement of actual witnesses on both sides would be by way of affidavits or declarations, as they're called, statements under oath in the federal system. And it'll be interesting to see who the FBI actually submits declarations for to speak to these 6 categories of evidence, and whether they assessed it, whether the original commission assessed it, whether the new commission assessed it. We think we've nailed down those facts pretty clearly for these 6 categories. So there may not be a lot for the FBI to say, other than, well, okay, this evidence is out there, but the original commission did not consider it, and the new commission did not assess it, but we shouldn't be required to for some reason, which I can't imagine what that would be since Congress ordered it. So, it'll be interesting to see who the FBI relies on to try to come up with some sort of defense on this, and I don't know what that defense is going to be. They can't recreate the original 9/11 Commission's report. They can't recreate the new 2015 FBI Review Commission report. It said both of those reports say what they say and don't say what they don't say. So there's no wiggle room there. The evidence is pretty well documented, and the FBI's knowledge of it is pretty well documented. So when you put all those facts together, I think the FBI's work is going to be cut out for them on this lawsuit.
Right. Now, how long could this process take? Because I know you guys said with the grand jury petition that whole process can be up to 18 months. And there's people eager for it to happen today and get some kind of result, because that's how we roll here in the truth community. We want justice, and we want it now. How long are we going to be following this estimated time?
Well, you're talking about, maybe 3 or 4 months on the motion to dismiss. I hope it's not longer than that. You're talking about another 3 months on the summary judgment, and that depends on how long the judge takes to decide the motion to dismiss. There's no deadline on the judge to make a decision once all the briefs are in. That could add some time, depending on the judge's schedule. And then if a hearing is scheduled, either an argument hearing for the summary judgment motions or a trial-type evidentiary hearing, that could take another few months. So, there's an outside chance the government might concede this because it's pretty cut and dried, and they might say, okay, we're willing to go back and do this right. If they don't do that, you're probably talking about a year to a year and a half in terms of getting to a conclusion from the district court.
Well, there you go. If that's as long as it takes, that's as long as it takes. So we've been waiting long enough. We can certainly wait a little longer. It's not Perry Mason. It's not going to be resolved in 2 hours. So one more question about this before we get to Richard and talking about how our supporters can get involved. How are we going to be able to follow this? Is this going to be behind closed doors and then we'll just have a final conclusion come out and that'll be the end of it? Or is there going to be something to follow during it? Or will that depend on what step it gets to? Like if there's a trial, we'll be able to follow the trial, but if it gets settled at step 2, then we'll just hear about a conclusion. How will our supporters be able to keep up on what's going on during this process?
Well, I'm sure that both architects and engineers and the Lawyers Committee will sort of give a step-by-step update as we go on our website. So that's one way, is to keep in touch with our websites. And if there are significant developments along the way, I'm sure we'll put out special news announcements on those. Now, your question is an important one because this entire litigation process we're talking about here in the lawsuit against the FBI is entirely public, as distinguished from the very secret grand jury process. So we don't have the secrecy cloak limiting what we can do to keep the public informed on this case. Anyone actually can follow all the filings and download them if they want. They're all going to be posted on what we call the PACER website, the Public Access to Court Electronic Records, PACER website. Anyone can sign up for an account and then access any filings in any federal court these days, including this one, and just follow every filing. And for those who don't want to go to that trouble, you can just keep checking our websites, and I'm sure we'll be posting the filings. So it should be pretty public, Andy, on this one.
Now, Richard, I know you're doing everything you can to help out this process, as is the rest of the staff. We certainly want to see justice. We certainly want to see the FBI do its job, even after some arm twisting all of these years. But we want to see the right thing done in the end. And there's many more supporters who are following this closely, very excited that this is happening. How can they get involved, and how can they most help out AE 9/11 Truth and the Lawyers Committee for 9/11 Inquiry?
Well, as everybody knows, lawyers are expensive, and so there's a lot of ways that we're going to need help here. And the chief way, of course, is through your financial donations, and it's absolutely critical. Now, these attorneys have already worked hundreds of hours to investigate the opportunities available for legal action like this, and then to create all the documentation. And they threw out more counts in this research work than they kept and included in the filing. You can imagine how much work it takes to sift through this evidence, and a lot of that work was pro bono, but that all can't be. And that's why we have a $30,000 Phase 1 fundraising goal in this joint effort with the Lawyers Committee for 9/11 Inquiry and Architects and Engineers for 9/11 Truth. We're a plaintiff in this lawsuit. We're taking huge risk ourselves here, not to mention the risk that the attorneys take, not just financially, because we're obligated to support the attorneys, even if we can't raise the funds. When we signed on that line, we're saying, hey, the 9/11 Truth movement is behind us. Well, $30,000 only takes us part way into this picture, and the second phase is coming up right behind this phase. So I think we've raised $20,000 so far, but we really need to get to the 30, and then at some point we're going to need more funds depending on which way this lawsuit goes. So I wanted to ask Dave to help everybody to understand what the phases are and how much we're raising for each phase and why. But whatever you can do, whether it's $10, and we have more than 600 donors so far to raise us $20,000. So yes, even if you can only give $10, you don't think it's much. But guess what? There's hundreds of us pooling our limited funds together, and it creates a pool that can force the FBI to disclose this evidence publicly. It's an incredible opportunity. So everybody, please do what you can. If it's $100, if it's $200, if it's $1,000, and if somebody has the wherewithal to provide a $10,000 donation today, that is the opportunity that can send us over the top easily. But every bit helps. Dave, how does the fundraising tiers work?
Well, as was mentioned before, the first hurdle is this motion to dismiss, and the complaint now has been generated. There'll be an opportunity to respond. The government has, and there will be then the motion to dismiss, no doubt, that has to be defended. And as we pass on to the next stage, there'll be briefs. There'll be a lot of mental work that needs to be put into this. There'll be the need to get declarations and affidavits, etc. And that's, again, it's labor and mental intensive. And then there may be a trial. So the first tier that we're asking for is the $30,000 to just to keep this action in the ballpark, to beat down the motion to dismiss. And then we want to raise more money, and we've set our goal as to overall $60,000 to defend the complaint as it's filed, and to be victorious on the summary judgment, or if not, if both sides aren't being able to have that summary judgment, then to be prepared for a trial. And so we estimate that certainly we need some money to do that, and if anyone has that wherewithal to contribute, they should contact or send contributions to lc4911.org or ae911truth.org, and that the funds that we receive will be utilized to keep this action alive and to be victorious in it. So it's a very significant action. As a plaintiff is not only architects and engineers and the Lawyers Committee, but also presently Bob McIlvaine, who is, of course, probably most of our listeners know that he lost his son in the North Tower area on 9/11, and is a stalwart who's been going forward since then to try to get truth and justice for his son. Mick, maybe you want to amplify that a little bit as far as how the monies will be utilized and why we need them.
Well, you nailed it pretty much, Dave. We have a $30,000 goal for the motion to dismiss stage, another $30,000 or so for the summary judgment stage, and then if we do get a trial, that's another chunk of money, maybe the biggest chunk for the third phase, which would be great, to get a public trial on this. It'd also be great to win a summary judgment. So we do need help at all these phases, and they, as Richard said, they come back to back without much of a pause. So whatever folks can contribute would be much appreciated. And I just noticed, and I'm sure Bob wouldn't want publicity on this, but I just noticed that Bob McIlvaine made a contribution himself. And as a family member and having lost his son in this tragedy, we really shouldn't rely on the family members to fund this. The rest of us should be doing this and doing our part. So all of you out there who can, we really could use your help on this.
Right. And if I could just add to that, Andy, this suit is, of course, we have our plaintiffs that we mentioned, architects and engineers, Bob McIlvaine, the Lawyers Committee. But really, this lawsuit is on behalf of the American people and on behalf of freedom in our country and on behalf of getting our Constitution back and protecting ourselves through the Bill of Rights being adhered to. So there's a lot more at stake than the named plaintiffs. And to help us see this through, people can do certain things just to, talk about it, get the issue out there. But certainly how you can directly help us is to send some contribution, which will go directly to basically informing the public and to try to rectify the wrong. And it may take a while to do that, but this is a process, and this is a very important step. So we hope that the listeners will acknowledge that and help out. and any assistance they can give us is most appreciated.
That's right, and I don't want to use the analogy of war because we have a bunch of peace activists in this audience, but any kind of war, whether it's the traditional kind or just a war of information or a war of legal action, requires funds. If you watch the John Adams movie on HBO, you'll see most of that is him out there raising funds for the revolution, and that is a reality that we face here in this world, and that's what's going to be what it takes to take on something as big as the FBI, which has taxpayer money available to it, so that they can ignore obvious evidence of controlled demolition. We're doing their job for it at a fraction of what they take in and the staff that they have. It's too bad that Richard Gage isn't working for the FBI and delivering this evidence and making this case, and it's too bad that we don't have people like Dave and Mick down there as well, or otherwise we'd have justice on this. We wouldn't have to exist. So you can go to the Lawyers Committee's webpage, lc4911.org. You can also go to ae911truth.org/FBI, where we've laid out this entire project, just like with the grand jury petition, just like with the Bobby McIlvaine Act. You can see the key documents related to this filing. You can donate there. You can get all of the relevant news updates. So ae911truth.org/FBI to keep track of that. And we really need all hands on deck. I mean, we're hitting them at so many fronts. This is the time in our history as a movement that we have all been waiting for, the time for truthers to rise and meet the call. We have the Building 7 study going, Bobby McIlvaine Act, grand jury petition, now this FBI lawsuit, and who knows what's going to come in the future. We got other things that we're planning surrounding some of those things, and we'll be talking about them in the next coming weeks, but we really need all hands on deck. And we are actually at the end of this hour now, but I want to know, guys, do any of you have any final thoughts you want to leave the audience with?
This is not just about a lawsuit, okay? The lawsuit is our opportunity to awaken the American people that they have been scammed on a scale that exceeds anything that the world has ever been deceived of before. We're talking about mass deception that was done on purpose to achieve a series of ends that we are not willing to live with. And that's why I'm in this game. I'm really upset. And that's what's fueled me for 12 years. We've engaged in a $6.5 trillion global war on terror. And guess what? It's all because of what happened on 9/11, which chiefly goes back to the destruction of these Twin Towers. And so if they were blown up and under a grand deception, then all of us owe it to our children and our grandchildren to do everything we can to bring out the truth of the situation and expose the perpetrators. That's what this lawsuit has the opportunity to do. That's why we need all hands on deck. That's why I and the Lawyers Committee for 9/11 Inquiry and AE911 Truth and our staff and our board are in this for the long haul. So join us and don't step aside and assume that somebody else is going to take the responsibility that you have now on your lap. So run with it, please.
Right. This is a historic moment now, and we're stepping out, and we ask others to step out with us, and we appreciate their support. And we appreciate you, Andy, for having us on.
Thank you guys for what you're doing. Good luck moving forward. We're certainly going to be keeping track of it. And Richard Gage, Mick Harrison, Dave Meiswinkle, thank you for coming on 9/11 Freefall today. This program is on every Thursday night on No Lies Radio at 10 o'clock Eastern, 7 o'clock Pacific. You can also keep track of the archives by going to 911freefall.com. This is Andy Steele saying have a great week and good luck.